I'm Matt Gearheart. This is No Holds Barred. We're pleased to have Justin Sonniksen here today. We're going to talk about workers' compensation. Justin is a partner at Gearheart Sonnicksen. He's been doing workers' compensation law for some time, and it's very important that people understand workers' comp. It's something that most people don't know, particularly lawyers. So we're very pleased to have Justin here today. So welcome, Justin.
Hi, man. Thank you for having me on your show.
Yeah, it's a pleasure having you here. Thanks so much. Why don't you tell us just initially a little bit about yourself, and then we're going to get into what exactly is workers' compensation.
Okay, thank you. So my name is Justin Sonniksen. I'm a partner at the law office of Gearheart Sonnicksen in Pleasant Hill, and we specialize solely in workers' compensation law. I grew up in Indiana originally, and I moved to California in 1998 and went to the University of San Francisco for law school. And I started in the field of workers' compensation in 2003, initially doing employer insurance side defense. And then in 2011, I became an applicant's attorney. And in workers' comp, we say applicant, not plaintiff. So since 2011, I've been representing injured workers at the workers' comp board. So I've been doing workers' comp for 19 years now.
I see. Well, I like to hear that because then you've seen both sides of it, both the employer side and the applicant side. So you're the expert we want to chat with.
Yeah, I do think it's beneficial to have done both sides of the issue. One of my clients said, this is like hiring an old IRS agent as your tax guy. So, because I understand what's important to the employer and the insurance company. And so that helps me, I think, in my representation of injured workers as well.
Yeah.
So,
Oh, that's great.
as a lawyer, it's always good to see both sides of any issue, right?
Mm-hmm. Very important. Well, tell us a little bit about what is workers' compensation?
Okay, so workers' compensation, it's an administrative area of law. We don't practice in superior court. It's, in a big picture, it's a compromise between employers and employees. And it's, in the early 20th century, there were a lot of industrial accidents. A lot of people were being, injured on the job without without an effective remedy in terms of tort liability. There were a lot of defenses that the employers had that the vast majority of time barred the worker from being able to sue for damages for workplace accidents. And so workers' compensation developed as a bargain between employers and employees where workers eliminated their right to sue for monetary damages for injuries at work in exchange for having a no-fault system, so they don't have to prove fault. So in theory, it's supposed to be an expeditious delivery benefit system where someone gets injured at work, we don't spend any time worrying about who caused what, so you eliminate a lot of litigation right there. In exchange, you get very limited monetary benefits for workplace injuries. Mm-hmm. So you can't sue for pain and suffering, loss of consortium, lost future earnings, things like that, things that would be available as a tort remedy in a fault system like personal injury law.
I get it. Well, for example, I mean, we had a case in which it was a PI case, and a person was driving a company vehicle on company business mm-hmm. when he was rear-ended. So he suffered an injury, and we filed a third-party case, a case against the individual who ran into him. But very quickly, we were contacted by a workers' comp lawyer, and he called it a workers' comp lien in the case.
Correct.
So could you tell us, just as an example, kind of in that case, how does that work?
Okay, so in the third-party context, the worker suffers an injury while working that's caused by someone other than his employer. And in that sense, the worker can sue the third party that caused the accident as well as pursue workers' compensation benefits. So now the employer has workers' compensation insurance. That insurance company is paying benefits through the fault of somebody else. So the workers' compensation insurance company also has a right in superior court to sue the third party tortfeasor, the one that caused the accident. And so when they provide benefits to the worker, they can file what's called a lien in the civil case so that the insurance company can get a recovery for benefits it had to pay to the injured worker in the workers' comp arena.
I get it. Let me ask you something more simple,
really
actually.
Quickly, it's a weird scenario where in some instances, the insurance company and the worker are actually on the same side because they're both trying to prove it was the third party's fault.
I see.
So.
I see. Well, let's just talk about just say employer fault. So the average person working in, let's say, a factory, and let's say something happened with a machine, or well, you often hear somebody hurting their back. They're picking up a computer at the office or something, and they injure themselves seriously enough that it causes them to miss work and all of that. So in that situation, then they can't sue their employer. So what do they do in terms of, do they contact a workers' compensation lawyer, somebody like you, to represent them, or how does that exactly work?
So in most instances, most workplace injuries are relatively minor. The person gets some treatment and goes back to work. So most cases don't involve an attorney. But in that situation, to answer your first question, yes, if he's working as part of his regular job, he's doing his job and his back goes out. It just happens to go out while he's doing his job. Well, that's a workplace injury. And that's correct. The general rule is you cannot sue your employer for injuries sustained while on the job. So he files a workers' compensation claim with the employer. It's called a DWC-1 claim form. That's the Division of Workers' Compensation claim form. Files that with the employer, and then the employer has to submit that to their insurance company. And then from that point, if they have insurance, the employer, in terms of the administration of benefits, doesn't really have a lot to do with the claim. It goes to the insurance company, and the insurance company administers the workers' comp benefits on behalf of the employer.
I get it.
So it's not a lawsuit. A lot of times my clients think, oh, I'm suing my employer, I don't want to get them in trouble, but it's not a lawsuit in that sense at all. It's a claim for insurance benefits that they're owed under the labor code.
I do want to get into the different kinds of benefits that one is, but that's a little later. What I do want to ask is, you said if they have insurance, let's say the state of California, are all employers in the state of California required to have workers' compensation insurance?
Yes, there are certain state entities that are allowed to be legally uninsured, but that's only for certain state, like the Department of Rehabilitation or something like that, but the Department of Corrections. But yes, the everyday employer, it's a crime to not have workers' compensation insurance. So you're required by the labor code to be insured for workers' compensation injuries.
I've had experience where, say, an employer, let's say a contractor, has actually hired workers, but on his state contract license application, he says he's a solo. So he doesn't, according to them, he's a solo. He doesn't have any employees, so he doesn't purchase workers' comp insurance. But he has really contract employees, and so what happens is somebody gets injured, makes a workers' compensation claim, and then it turns out, he lied. He does have employees actually, but he doesn't have insurance. How does that work in our system?
So if you sustain an injury while working so let me back up. The presumption is if one does work for another for the benefit of another, the presumption is that they're an employee. That's the statutory presumption. Obviously that can be overcome, but that's the general rule is there's a tendency to find that one who does work for another is their employee. So if the employer does not have workers' compensation insurance, the worker has the remedy. That's one of the exceptions to the rule that you can't sue your employer. If they're uninsured, you can sue that employer in superior court. And there's actually a presumption that the injury that happened at work is the fault. It's presumed to be the fault of the employer. There's a presumption of negligence. And there's also a penalty. All your workers' comp benefits are enhanced by 10% if the employer is uninsured. Now, sometimes the employer doesn't have funds to actually pay the workers' comp benefits. So there's a fund called the Uninsured Employers Fund in California. And so the employee petitions to join it's called the UEBTF, Uninsured Employer Benefit Trust Fund. And they become a party like an insurance company in the workers' comp case. And once they're properly joined, they administer benefits like the insurance company would. But then the UEBTF has rights to sue the employer as well to recoup what they paid to the worker in superior court. So The consequences are quite severe if you don't have workers' compensation insurance coverage as an employer. Not only monetarily, but it gives the worker the right to sue you in superior court for the workplace accident or injury.
I see. So I think one of the important things of this episode that we're talking about is to ensure that the listeners, particularly employers, appreciate the fact that if they have employees, they need to have workers' compensation insurance. So the question is, how expensive is workers' compensation insurance?
That's a very good question, and it's hard to answer because there's a lot of variables involved. A big thing is payroll. A lot of the insurance cost is dictated based on how many employees you have and how much you pay them, because they determine, if there's a claim filed, how much are we going to have to pay for temporary disability benefits while your employees are off work. So a lot of it's payroll driven, and a lot of it's driven by the risk inherent in the job. So the rate for a construction company would obviously be higher than a doctor's office, because the insurance company is not getting very many claims for serious injuries from the doctor's office versus construction sites where injuries are quite commonplace. So obviously the risk of the job involved and how you categorize your workers is a big factor in what you get charged for workers' compensation insurance. And obviously the more claims that are filed against you, then the insurance company adjusts your rates going forward. So it's hard to give you a specific answer in terms of how much it costs, but the simple way to put it is, the more employees you have, the riskier the job is, the higher the cost is of the insurance.
And of course, from a business standpoint, the risk is borne by raising prices or charging to accommodate that cost. But I think the moral of the story is very important that employers need to have workers' comp, because it sounds like the penalties, the things that happen to them if they don't and there's a serious injury, are greater than if they had simply purchased the insurance in the first place.
Absolutely. Right? Oh, absolutely. No, without question. And plus, even if there isn't an injury reported, if recently with the new district attorney in Contra Costa County, she'd been dedicated to trying to find out employers who were uninsured, and it's relatively easy for the state to find out. And some of the local employers were fined for not having insurance coverage, workers' compensation, even though there weren't any claims filed. Just not having insurance, if the state finds out, that you can be penalized. So it is a serious crime to not have workers' comp insurance.
I see.
And the theory is, you stated earlier, that's correct. The employer is in the best position to pass those costs on to its consumers in terms of what they charge for workplace injuries. So that's the theory behind workers' compensation.
Right. Well, in this first episode, I like this idea of the overall flavor. So we've talked a little bit about the employer. I do want to switch over for a short term and talk about the employee.
Okay.
And the issues always come up. First of all, is there workers' compensation? Is it the nature of the injury? Was it something that was employer fault, or I know you say not fault, but when somebody was employed or not? Because occasionally we hear that somebody, they put in a claim for workers' comp, and wait a minute, it's denied because it's not within the scope of their work.
Yeah, so in workers' comp, we don't use the term scope of employment. That's a personal injury term. We use arising out of and occurring in the course of employment, and both of those have to be met. So the injury has to both arise out of, meaning there's some tangible connection between the job that person did and the causation of the injury, that the employer somehow benefited from the work that person did that led to the injury. And then in the course of were they actually doing work for the employer at the time that the injury happened? So both elements have to be met.
Okay, let me give you an example then. That case that I was talking about where an employee was hit by a third party driving a company car on his way to work. And initially the thought would be, he's not within the course and scope, he's just driving to and from. But in this case, because of the nature of his work, it was required that he take the company car home and be on call. So in that case, it was found to be that he in fact was within the scope of his employment, and the workers' comp case got involved. But I've heard of others, we call it the going and coming rule or
Right.
whatever. Could you explain that a little bit?
Yeah, I was just about to. So if I have a fixed place of business, and let's say I'm a secretary at a law firm, and I live in Concord, I drive to Walnut Creek every day, same commute every day, and I get into an accident on my way to work, that's not covered under the workers' comp system. It's barred by what's called the going and coming rule. So the injuries sustained during your regular commute are not covered by workers' compensation. And then there's a lot of exceptions to that. For instance, if the company car exception, you're required to use the company car, or there's a special errand, a special mission exception. Your boss tells the secretary, hey, on the way home, can you go to this office and pick up supplies? On your way there, you get into an accident. That would be covered because you were directed to go on a special mission by your employer. So that would be covered under an exception to the going and coming rule.
Mm-hmm.
But the general rule is a fixed place of business, regular commute, injuries sustained during that are not covered by workers' compensation.
I see. All right, yeah, a question comes up often about, and people are saying, but it's really the fault of my employer. This wasn't just that I picked up a computer or, some minor thing happened. I mean, there was some pretty significant fault, I know you don't like that term, in this system, but on the part of the employer, which resulted in significant injury to a worker. Is there something in the system for an enhanced penalty or enhanced recovery for an employee?
Really quickly on the fault issue, the reason I'm smiling is because I had a client a few years ago who I told her, you are now my favorite client because I'm going to use your example. Because a lot of my clients will complain, well, the employer shouldn't have me do this or that. It's their fault I got hurt at work. Well, I had a client who was working as a social worker, having to drive around to see clients. She runs a red light, gets T-boned, very serious injury. And but she still got full workers' compensation benefits. The injury was 100% her fault. There was no, she had no civil recovery. But because it happened workers' compensation, it doesn't matter whose fault it is. So I said, you are now my example for all my clients who get angry that
I see.
we usually don't even care whose fault it is. It's just, were you working? Did you get hurt? Benefits are owed.
Gotcha.
So to answer your question about enhanced penalties against the employer, there's an exception called serious and willful misconduct. So if the employer causes the injury to a way that's they call it quasi-criminal, to where it's an intentional violation of a safety, or like a Cal OSHA safety regulation, that they know is going to be the proximate cause of the injury, and that the worker is actually injured as a result of that violation, the employer can be penalized for serious and willful misconduct, and then the workers' compensation benefits are enhanced by 50%. Again, with the no-fault system, they're very hard to prove. It's not just negligence, because a lot of times my clients say, oh, the employer was negligent. The employer can come to trial and say, yeah, we were negligent. We didn't do X, Y, and Z. But it's got to be way beyond that. It's got to be intentional, that they intentionally violated the safety rule. They knew it was probably going to lead to an injury, and it did. And it has to be someone in charge at the employer that that had the ability to correct that and intentionally did not. So they're incredibly hard to prove. But in that instance, the employee's benefits can be increased by 50% if the employer is found to have engaged in serious willful misconduct. And then lastly, even harder to prove is if the employee engages in serious willful misconduct in causing his or her own injury, their benefits can be reduced by 50%. Although in 19 years, I've never actually seen that prevail. So it's almost impossible to prove the other way. But
well, that's interesting, because I very much want to get into, I think we'll save it for the next episode, the actual benefits. So we've talked about how an employer can be not faulted, but the employer can actually, the cost to an employer for the serious and willful, or just normally insurance costs and all that. But we haven't had a chance yet to talk about what are the benefits that an employee gets. And we've heard terms of what temporary benefits, or all those different things, which I think going to clearly take up another episode fully just to discuss the issues of what a worker actually gets, how long do they get to have benefit of disability benefits, and even in some cases be permanently disabled and never return to work.
Yeah, and the benefits are quite limited and set forth by statute, so we can go through those one by one.
Oh, that sounds great. That sounds great. That concludes this episode of No Holds Barred. Stay tuned for our next episode of No Holds Barred, where we meet with Justin once again and discuss workers' benefits in the workers' compensation system.